Well, hello and welcome to the inaugural episode of Finnegan's Women in Litigation podcast series. My name is Erika Arner, and I'm joined by my colleagues Kara Specht and Arpita Bhattacharyya, who are going to address some of the most common questions we hear about practice before the Patent Trial and Appeal Board and share some of our experiences navigating them. I couldn't think of two more qualified attorneys to be here for this discussion. So Kara, Arpita, thank you for joining us today to share your expertise. Great to have you.
Thanks for having us.
Kara, I'm going to start with you. You have appeared at the PTAB nearly 80 times, so you know your way around. For those who may not have as much experience as you do, what do petitioners need to know about what makes a good invalidity challenge to bring before the PTAB?
Sure. So of my nearly 80 appearances, I think 78 of them are on behalf of the petitioner. So this is usually what I am doing when I'm before the PTAB. And I usually like to say that a good challenge boils down to two things. The first one is precision, and the second one is simplicity. So what do we mean by those? For precision, to present a good challenge before the PTAB as opposed to perhaps a district court where you're before a jury that might be a bit less technologically savvy, you really have to be precise to the claim language, precise in mapping the prior art, detailed, get a good expert who can explain things at a deeper level than you might use before other venues or in other jurisdictions. Simplicity, and maybe this sounds like it contradicts the precision, you really need something that makes logical sense and is easy to follow. So I like to think of it as digging all the way down in the weeds to be precise, but then taking it up 3 levels to make sure you're simple enough that you can explain it to somebody who's not technically savvy. And that way you can accommodate all levels of experience that you might get in judges or anybody else that's listening to your argument. So, usually before the PTAB, you have at least one judge has some experience in the area of technology that you're working in. The other 2 may or may not. So you want to make sure you're speaking to all 3. Hitting the precision and making it simple is the way, in my view, to present the strongest challenge before the board.
Terrific. And you have a limited word count, right? So you have to accomplish all of that in a very tight amount of words.
And concise, if we add one more, for sure.
Great. So when you're thinking about, let's stay with the invalidity challenges for a minute for petitioners. There are by statute a few different types of invalidity challenges you can bring. Not all invalidity challenges can be brought at the PTAB. Tell us what your view is of whether a Section 102 anticipation type of argument could be successful or have a role in a PTAB strategy.
Sure. So maybe to start with just a bit of background. So before the PTAB, you cannot use what we know as system art. You can't present a product or a prior sale. You're stuck with what we call the publications. So you must use printed publications that qualify as prior art or patent applications. Those are always my preference. And then you have 2 types of challenges. So I think your question, Erika, was about anticipation. Anticipation means you have one document, one publication, and within the 4 corners of that document, everything in the claim you're challenging is clearly disclosed exactly in the way that it's also claimed. So it's a fairly high bar. You only get one reference. On the other hand, obviousness, or what we call a 103 challenge, you can have multiple printed publications, multiple references, and you would present a motivation to combine. So you could take bits and pieces from multiple documents and present a logical reason that a person of skill in the art would find the claims obvious over all of your different references. My general rule of thumb when at the PTAB is that obviousness is a better challenge to bring than anticipation. It gives you a bit more wiggle room. It allows you to lean on the expert. It lets you bring in the knowledge and common sense of a person of ordinary skill in the art a little bit more. Anticipation is generally viewed as a more rigid legal framework. Now, that said, to your question, there is a time and a place for an anticipation challenge at the PTAB, and if you can do it, it is a more powerful challenge. To come in and say everything is in one reference, everything is clearly disclosed. When you can present that without stretching too far and you can make a credible anticipation challenge, that's what I would call the gold standard. Now, if you find yourself reading your references and you say, maybe this is anticipatory, you can use obviousness as a backup. And my standard is usually, unless I'm very, very sure it's anticipatory, I would present it as both. an anticipation reference and a single reference obviousness, for example, or perhaps adding in a secondary reference as well to shore up an obviousness combination. I have one maybe cautionary tale example where we did present a 102 anticipation challenge only. The entire hour-long oral hearing was nothing but questions about, are you sure this is truly anticipatory? Are you combining embodiments within your single reference? Yes, we see it's all there. Is it there presented in the same way that it's claimed? And at the end of the day, it was not in there, according to the board, it was not in there in the same way that the claims presented all the different limitations. And in the final decision, breaking my heart, the board went almost so far as to say a single reference obviousness challenge may have worked. I think their exact words were, petitioner presents only anticipation, not obviousness. We are bound by their anticipation challenge, and we don't find the prior art anticipate. So when in doubt, use 103 as a backup.
I'm sure that was not your favorite decision from the board.
A learning experience for sure, and now we can all learn from it, right?
That's right, and that's part of the practice, right? Is learning and improving for next time. Kara, you mentioned the entire oral argument, 60 long minutes, which compared to a lot of other places like the Court of Appeals for the Federal Circuit, many motions hearings, it's much more time than you might expect. Can you walk us through the nuts and bolts of what an oral hearing is like at the PTAB?
Sure. So most times for an oral hearing, both parties prepare demonstratives that are submitted in advance. The PTAB generally does not like presentation of slides on a screen. You can do it if you are in person. Oftentimes, some of your judges are virtual, if not all of them virtual. So you really have to know the arguments in a way that you can refer the judges to your demonstrative slides and also to places in the record. So they sit up there and have the entire record open before them and are following along. So while it might be a bit different than in a district court and more similar to the Federal Circuit, perhaps, where they know the record very well, you have to know it too. And you need to point out where things are. I think what's most fun about PTAB arguments is how well the judges know the record before them. They know the arguments. They have read the briefs. They have read the references. They have read every word of the deposition transcripts that you've put in, and they expect you to know it all as well. And so I think it's kind of fun to be able to speak with the judges in such detail about the technology. It's almost a bit of a like a spelling bee test, right? Like, where is your best evidence for this point? And you can find it and present it. And they really do a nice job of keeping it conversational. And that's, my first oral advocacy experience was before the PTAB. And so it was a very, I guess, encouraging forum to be in, to have judges who care so much, who want to get to the right answer, who like to hear about the geeky technical stuff and the specific citations in the record. Unlike the one I just gave you, Erika, the example where it was very legal heavy, and sometimes that happens. My experience is mostly the oral arguments are rooted in the technology, rooted in the patent. The judges know the law. They want to hear about the technology and your arguments, and that makes it a bit different, and I like it myself.
Great. Arpita, let's turn to you. You've also got terrific experience at the PTAB with nearly 50 appearances there. And in the time that you've been practicing, I know that you've seen some big changes in the law. Could you just let our audience know what are some of the biggest changes you've seen, and how have you and your clients navigated them successfully or learned something important for next time?
Sure. So since the AI was implemented, there have indeed been many changes that have recalibrated PTAB practices. And some of those changes are more significant than others. For example, the change of the PTAB's claim construction standard from broadest reasonable interpretation to the Phillips standard did not have any practical impact in my view, although it sounded like a big change. Then there was the highly anticipated Artrex decision, which posed an existential threat to the PTAB, but fizzled at the Supreme Court. So in my view, of all the changes that has happened, the most impactful and controversial was the expansion of Section 314A discretionary denials in view of parallel district court litigations. We generally refer to this as a FinTIP denial based on the PTAB's May 2020 presidential decision in Apple v. FinTIP. Under FinTIP, the PTAB gave significant weight to district court trial schedules that were often unrealistic and denied institution if the scheduled trial date was ahead of or close to the PTAB's final written decision date. And because of FinTIP denials, IPR institution rates dropped significantly in 2020 and 2021. But this practice has faced a lot of backlash from petitioners, and so Director Vidal has issued new guidance on FinTIP, which has reduced the number of FinTIP denials, although I would say FinTIP is not dead yet. Now, Erika, you also asked about how have I and my clients navigated this change. Well, the rise and fall of FinTIP has been very interesting. I represent both patent owners and petitioners. It's almost 50-50. So when representing a patent owner who is also involved in a parallel litigation, to me, it still makes sense to ask the PTAB to exercise its discretion under FinTIP if the scheduled trial date is close to the PTAB's final written decision date. And I often do that when representing patent owners. But when representing a petitioner, I don't take a one-size-fits-all approach with FinTIP. Rather, the considerations vary from case to case based on the district court's trial schedule, the invalidity positions that are taken or are to be taken in the district court, the amount of risk the client is willing to take, and several other factors. And there are ways in which a petitioner can make the IPR petition FinTIP proof, but you have to really consider the pros and cons of doing that for your district court litigation.
So Arpita, you do a lot of work in district courts as well as before the PTAB. So could you share with us some of the big differences between litigating in a district court versus at the PTAB?
Sure. If you say a PTAB proceeding is like a game of chess, then I would say that a district court litigation is like playing three-dimensional chess. So as a patent owner, the positions you take regarding validity at the PTAB always have to be consistent with the infringement positions you take in district court, because there is a very well-known axiom in patent law that the claim cannot be twisted like a nose of wax. It comes from decades-old case law. One way to preserve validity and another way to assert infringement. So consistency between validity and infringement is very important, regardless of whether validity is challenged at the PTAB or validity is challenged at the district court. But that said, in district court, you have to worry not only about validity and infringement, but also damages, equitable challenges, design arounds, non-infringing alternatives, and various other considerations that affect damages. And you have to avoid contradiction among all these considerations, which I think makes district court challenge more challenging than a PTAB trial. And then there's discovery. You get to do a lot more fact discovery in a district court case. And although a little bit of discovery is allowed in PTAB proceedings, it's not to the extent that you would do in district court. So you have to plan accordingly for a district court trial. The other significant difference that I would highlight is the schedule. With the PTAB, because there's a statutory deadline, the schedule is predictable and there is little possibility of gamesmanship. That's not the same with the district court case. The schedule depends on which district you are in. Sometimes there are patent local rules that guide the case schedule, but many districts don't have patent-specific local rules. So there is more room for delay, not just by the parties, but the court itself may take longer than expected to issue orders. So the schedule rarely goes as planned, and that's something you don't have to worry about at the PTAB.
All right. Erika, thanks for asking such great questions, but given your much vaster experience before the PTAB than Arpita and I think you have more than 200 PTAB trials under your belt, most, if not all, as lead counsel. We want to ask you a few questions now. So first, what do you think is special about a PTAB trial? And if you don't mind taking a trip down memory lane, what do you remember about your first PTAB trial?
Oh gosh, my first PTAB trial. Well, that's one of my favorite things because it was the first PTAB trial. I was fortunate enough to be lead counsel filing the very first petition before the PTAB when it was created. We filed it. Started filing at 12:01 a.m. on a Sunday when the PTAB first opened, and I think the that sort of set the stage for what is my favorite thing, which is how much of a PTAB trial is a partnership between the board and the parties. It's really a collaboration. Arpita mentioned there is not a lot of place for gamesmanship. And that has been my experience since the very first PTAB trial. When we filed our petition, we drove over a copy in the middle of the night, and waiting for us at the Patent and Trademark Office were the judges, the brand new judges on the brand new PTAB. They were so excited to start receiving petitions and start this entirely new world. And throughout that entire first case, everything we did was the first thing. So back then, you used to have an initial conference call as one of the first things in the case where the parties and the board got on a call just to discuss logistics and how things would work. And our initial conference call, I think, had about 100 people attending because all of the board judges were invited to participate by listening so that they could hear what these things sounded like. And so we were making it up as we went along, but the board was an active participant just as the parties were. Throughout that whole case, we had a lot of different questions about how does this work under the rules, or is there a way to do this special procedure that maybe isn't covered? And the board would engage the parties, get feedback. Often they would say, why don't you write us a 5-page paper explaining how that would work under the statute, this brand new statute that we're all learning about. And it was a really fun time and really terrific, I think, for the patent system and the public and all of the reasons there are patents, that the office was so engaged and working so hard to get it right. And I think that's remained my experience at the PTAB over the hundreds of trials that I've been fortunate enough to work on, is that the board is really trying to get it right. You mentioned the geeky nature of the practice. They are happy to talk about all of the technical details, all of the prior art, and really make sure that they're making the best decision based on evidence and the law. And it's really gratifying and a very enjoyable way to practice.
I have a question for Erika too. Since you have so much experience, I really want to know how you prepare for a PTAB trial, and is it different when you are representing a petitioner versus a patent owner?
How I prepare. So I think if it's for an oral argument itself, which I don't do too many of anymore, one of my other favorite things about the PTAB is that the office and often clients are very supportive of junior attorneys getting argument opportunities on PTAB trials because they often know the record the best. So I'm happy to give those opportunities whenever possible to others on my team. And so I don't argue there as much as I once did. But my preparation has always been the same when I am arguing, or if I'm even helping someone else prepare to argue, and that is to dig right into the record. And I spend, even if I've read all of the papers, either written them myself or more often reviewed them, I have them all printed new in a binder because I use paper. I'm from that generation, and I reread everything in the record. It really gives you a sense of the case. And, to Kara's point, an oral argument really it's a spelling bee. It's a quiz on show us the best evidence and really show it to us. Give us the citation line and column number. And that part there's only one way to be able to do that, and that is to know the record. And so for me, it's all about that kind of preparation. There really isn't a shortcut to get to where you need to be before an argument at the PTAB. It really is just a matter of really working through the record. As to your second question, whether it's different for patent owners or petitioners, I do think it is different. many of my first cases were for petitioners, and it was back in the day where 80% of petitioners won, and it was really a kind of a fun time, honestly, if you were a petitioners counsel, because you could kind of just walk in with the institution decision and say, "Hey, board, look how right you were. Here it is. In the institution decision, you found all these things, and you were right. Just stamp final on it. We'll call it a day." That was early days in the practice. Certainly, it evolved a lot since then, and it is a much more balanced. But patent owners have always had a bit of an uphill battle, I believe, at the PTAB. And for patent owners, often the strategy is more nuanced. And so, preparing for an oral hearing, if you have seen weaknesses in your own patent, figuring out how to best approach that at the board, and sometimes focusing very specifically on perhaps a subset of the challenged claims, recognizing that maybe you won't save the broadest claim and you might need to focus on some very meaningful dependent claims, which could still be very useful to a patent owner. Really having those tough discussions with a patent owner and making that part of your strategy throughout, I think is a definite difference between a petitioner where it's just full on invalidity, all the claims, basically. The patent owner, needs to be more strategic. And then, as you mentioned, Arpita, also be thinking a lot more about the impact outside of the PTAB with their patents, either in parallel litigation or later litigation.
Erika, you have been part of some landmark cases at the PTAB, including the very first one filed. Which one has meant the most to you?
It's like picking one of your favorite children. I can't do it. But it has been fun. That first case was pretty remarkable. The oral hearing, it was the very first oral hearing before the PTAB, and the experience of going in and having the solicitor from the PTAB, who's now a federal circuit judge, came to hear me argue and just see and be there. They had all of the 5 or 6 hearing rooms dedicated for our one hearing because they had lots of overflow space because so many people wanted to come to it. They gave out tickets because there was such demand to be in the room. And so I still have the paper ticket from that argument, which was the very first one. So there were a lot of sort of commemorative landmark kind of moments in that case. There was also a ton at stake for the parties. And so it was a high stakes case. And we ultimately prevailed for our client. And so that was also really meaningful. But I was grateful to be a part of that and to have a good result for our client. The one other that really stands out was handling the covered business method patent challenges to the data treasury patents. There were 2 patent numbers specifically called out in the statute when Congress enacted the covered business method patent challenge provisions. And I was hired as lead counsel for a petitioner to file challenges to those 2 patents. And they were so well known and had been mentioned by Congress as patents of concern for that procedure. I heard from a number of people who were not involved in our case at all, who were following it and who were aware of the situation around those patents and were encouraging. And so that felt like it was sort of implementing part of what Congress actually meant by enacting the AIA, and getting to play a small role in that. In those cases was kind of gratifying. We also were successful in those cases, so winning is always great for our clients, of course, but for me personally too, to succeed there was really great. Arpita, Kara, thank you for being 2 of our firm's most accomplished PTAB litigators and leading women in our practice, and for being our first 2 members of the firm to participate in our Women in Litigation podcast series. It has been a true pleasure to watch both of you grow your practices and succeed the way that you have, and we are looking forward to many great things to come from you in the future. Thanks, everyone, for joining us.